Judge Peter Cahill in the Derek Chauvin case may have ruined the entire defense. I'm Andrew Esquire, and this is the Legal Mindset, where we give you the unfair legal advantage. So this week, we had the prosecution go through a whole slew of witnesses before finally resting. But unfortunately, that wasn't the only thing that happened. Unfortunately, there was another shooting in Milwaukee where you had an unarmed black male who was shot by a female white police officer. Now, that was happening at the exact same time as the George Floyd trial is going on. And there's a lot of issues that have come up for the judge in this case, Peter Cahill. And to his defense, it's hard being a judge. You're gonna make some calls wrong. And it's easy for anyone, for any lawyer out there, for any Nancy Grace, any other spectator, to armchair lawyer, to say, hey, they should have done that, they should have objected to this, they should do that. And you're gonna see that. You're gonna watch a lot of channels and you're gonna see commentators, other lawyers, people who perhaps never been in court calling things, saying the judge should have ruled this way or that way, just like you're refereeing a football game. But it's not that easy. We're not there in court and we're not seeing the things as they play out. But when there's huge issues, when there's things that could possibly ruin the defense, that could defeat the possibility for a not guilty verdict, those are things that we have to call out, that I feel a duty as a lawyer to call out because they're important and because you need to know this. Because one of the most fundamental rights in the Constitution is your right to a fair trial, to a trial by an impartial jury, to a full defense where you're allowed to defend yourself with everything that you can. So let me point out this week some of the huge mistakes by Judge Peter Cahill. Well, let's talk with the first one. So we've just seen the prosecution's case. They're at the end of their case. And at the end of the prosecution's case, it will now transfer to the defense. So the prosecution will be done calling witnesses and it will transfer over to the defense to call witnesses. And what have we seen so far? We have seen a ton of expert witnesses. And honestly, a lot of them are saying the same thing. And one objection, which we finally saw in the final day of the prosecution's case, was the defense attorney saying, hey, judge, this is cumulative. This is the same stuff over and over. You're not supposed to do that. Because when you allow that, when you allow cumulative evidence, it makes it sound like it's decided. It makes it sound like everybody agrees, like there's nobody else that objects. It also bores the jury. They're forced to be there. A lot of them don't want to be there. And in this case, in the case of this particular trial with huge political ramifications, a lot of them are scared. They're scared for their identities to be revealed. That's a huge thing. While they're there, scared and tired, you're seeing the prosecution drag out witnesses that are largely saying the same thing. They've dragged out a bunch of medical witnesses to say that the prone position is bad and shouldn't happen. They've also dragged out pretty much everyone in the police force ever to say that the use of force was unreasonable. Now, of course, the defense is going to have their own experts that are going to say it indeed was reasonable. That's part of the case. But they went a little far on the prosecution side, and the judge should have called that. He should have stopped that. But what else? Well, when you have a big event like this shooting that occurred mere miles away in Brooklyn Center from the courthouse, the judge should have allowed the jury to be questioned on it. Now, why is that? Jury selection is a key part of the trial. You want a fair trial. You want people who aren't biased, who already haven't made up their mind. If someone is watching media or very political and they have made up their mind one way or another, and let's be clear, I'm for a fair trial. It should go both ways. So I don't think anybody who's strongly involved in BLM or Blue Lives Matter or has a family member who's a police member or a family member who's an activist, they shouldn't be allowed on that jury. That's strong for either side, wherever you sit in terms of your fundamental beliefs. But what they didn't do, what they failed to do, is ask the jury how they felt about this latest interaction, if that changed anything, if they feel scared, if they feel intimidated. Because after this latest police shooting, there are already protests in Milwaukee. And one of the jurors lives and has connections near Brooklyn Center. So they have reason to worry personally. And that brings us to another huge failure on the part of Judge Peter Cahill. And that is, he has not sequestered the jury. Now, what's sequestering? What does that mean? That means taking the jury out of their normal environment where they normally are and putting them in a hotel, putting them somewhere that's protected, putting them away from the media, so they're not questioned when they go home, so they're not bombarded by social media, so they're protected and controlled. In extreme cases like O.J. Simpson, the jury was sequestered for up to 265 days. I know, that's crazy, almost a year. And honestly, sequestering is tough. You don't get anything in your room. You don't get a TV, you don't get a newspaper, you don't even get a Bible. I mean, you've got almost nothing in your room. But it protects the case. It protects you from that influence, and it ensures that you're getting an impartial trial. But what happened here? Well, the defense attorney, he said, hey, look, it's time for these jurors to be sequestered. There's protests going on. Those protests could easily change into riots. And the safety of the very jurors could be at hand here. And mind you, in this case, there already was an incident of a single person who was associated with the defense who was taking pictures in the elevator. Mind you, cameras are not allowed in courtrooms for good reason. Because if the jurors' identities are exposed, they could be threatened, and that's not good. So you already have potential exposure, you have risk. This is a high-profile case. Everybody's paying attention to it. So you really needed these jurors sequestered, especially when there's problems out there and when there's new issues in the media that could potentially influence this jury. Because that influence, that outside influence, is what you want to avoid. You want them making a decision based on the law, based on the actual laws, not based on their personal feelings, based on what the social outcome might be. You want it to be fair. You want it to be just. And that's what we all deserve. We all deserve justice. We all deserve fairness. That's not saying that what happened was right or wrong, but regardless, you are entitled to a full and fair defense. I believe that very strongly, and it is a fundamental principle of our Constitution. But despite this, Peter Cahill did not care. He did not allow for the jurors to be sequestered. And that's why there's a huge issue in this case. And Peter Cahill may already have decided this case. Why? By the very charges he allowed. So check out my video, Is It Murder?